Lordship, if I'm permitted to make a mention. My Lord, I beg to mention item number 56, Bistarjun Linkoy.
Item number?
56.
56?
Senior Counsel, Mr. Asoi is saying, my
The
Lord.
56 matters in the list today.
2022, my Lord. Item number 56.
Yeah, okay.
My Lord, objection.
4 weeks, yes.
Highly obliged, Lordship.
We can take it 3 weeks. Yes.
May I please, Your Lordship? Your Lordship, I would like to mention item number 43 and 53.
53 and 43.
Yes, Your Lordship.
You've informed the other side?
Yes, Your Lordship.
Yes, 3 weeks. 3 weeks, yes.
Highly obliged.
Yes.
May I please, Your Lordship? I beg to mention item 59 and 62.
3 weeks, okay, 62, yes.
I've already informed the other side.
Yeah.
I've already informed them. Obliged.
They never object, no problem. Yes. Yes.
Your Lordship, I beg to mention item 52.
32.
52.
52.
And similar prayer for items 60.
Item?
60. 60.
60. 52 and 60. 3 weeks, yes.
Highly obliged.
Main list, item number 1.
Please, Your Lordship. Lordship, item number 1 to 5, Your Lordship, connected matter.
I don't think I can take up this matter. Because point number 5 was my client once upon a time.
I'm aware, Your Lordship.
You're aware of that, correct?
Yes,
This is matter for any other bench or any bracket.
Obliged.
Much obliged, my Lord.
Please, Lordship, beg to mention item number 57.
Only matter only started.
Item number 6.
You have to wait for it to come, Mr. P.T. Sama. I don't. You're a senior counsel, you're senior, practitioner now. What will the juniors say? They'll start following you then. What is this, Mr. Roti?
But Your Lordship, during this COVID period and all that, and after that, the rent deposit had not been possible. The courts were also closed, and it was not possible.
This is a 2 to 6 matter.
2 to 6 minutes.
Why?
Because now we are basically praying for allowing us to deposit at one time. So government is because government it's the law of the government, whether they have any objection to that. Private party, I don't think they have anything much to say, because it's not going to be.
What's the case? They didn't allow rent deposit from when?
Since the beginning of COVID. And then after that, we have stated that there were some efforts at negotiation and all that. So finally, it has failed.
Efforts for negotiation means for settlement.
Talking to the settlement and outside thing.
You are appealing for?
State minutes. Private party will have to be heard. Lordship,
So
I was
my
just telling
friend
my
tells me that similar order was given in.
Lordships had granted this protection, because I recall I had raised it myself. Lordships will recall the extension orders in the COVID matters.
That is different.
No, in that Lordships had granted protection for rent deposits. For those people who could not approach the court because of the limited functioning of courts. These are the list of orders.
Oh.
Kindly see the second
Right.
order at 15/6/2020. It's in the 3rd page.
The time when the old chief justice was there, he left us. He left us in the lurch. Yes.
Well, I would pray that notices may go and whatever.
Yes,
So the original protection orders did not cover rent deposit matters under section 5(4).
Okay. Let them at least get notice. Heard Mr. S. Raghuvathy, Council of the Petitioner, issue notice. Mr. S. Sen is present. Accept notice on behalf of spot number 1. Steps to be taken in 3 days. List after 3 weeks.
Item 7.
Seven.
Please, Lordship, number 7.
Beri tu orders. Beri motion. Beri tu orders. Beri just find out. Beri tu orders saja. Beri orang find out. Beri tu orders. And all the current motion beri tu orders. Beri. Find out mana boleh tu. Itu baru nak punya file yang tentang page order sampai. Yes, Mr. Sangma.
Yes, Lordship. This is the case, Your Lordship. This petitioner is the mother and the brother of the deceased who died on election duty. Now, what happened, my lord? There was a petitioner. The deceased was employed as an assistant, technical assistant in the MRGS, in the government employee, and he's a government employee. He's working in MRGS.
He's working at sanctioned post.
In the sanctioned post.
He is sanctioned post working as what?
As a technical assistant. Technical assistant. Now, what happened? That he was.
What's the grade of technical assistant?
Without going to merit of the case, Your Lordship, this rate is not maintainable, Your Lordship.
Okay, yes.
My submission here, Your Lordship.
Of course.
He died on the election duty. It is due to the gross negligence on the part of the state respondent. Why? Because he was deployed by the respondent authority for election duty. There is a certain procedure. That election, the state respondent, the returning officer, they have hired the vehicle, which is not even that there was no proper document with the vehicle, and moreover, that vehicle which they have hired is a goods carrying vehicle, not for the passenger, which is not for the mean for passenger. Good carrying vehicle means, Lordship, like there is without any proper this one like bolero camper, something like that, which is the good carrying, not for passenger. And secondly, my lord, at the time of incident, when he died, that state respondent, they have never even taken an initiative even to inform to the petitioners, the mother and the family members. And worst thing is that even they have not even taken an initiative even to save the life of that person who that disease. Because
what do you mean?
Why means like they have not taken even the ambulance to for emergency care. It is the petitioner.
They left him to die on the side of the road. That's what you're saying.
That is what I'm saying, because the private respondent, this respondent the petitioner have taken the private ambulance to take the disease from.
Okay, what happened after that then?
After that, he has taken to the various hospital in Guarpara for taking care. At the time, on the way, after reaching, he succumbed to his injury. He passed away. Now the case of the petitioner here is that.
What do you want?
We want just at least this adequate compensation have to be paid by the state respondent. By the respondent authority, because
whatever compensation will be in a conflict law, ex gratia pay will be paid by election department, whatever is first benefits you will get.
Lordship,
then what do you want with this petition?
They were saying that they should give some adequate compensation.
What's adequate compensation
for that person?
Then what's adequate compensation?
Because he was working.
What's adequate compensation? Now have you paid the ex gratia payment? Have you received the ex gratia payment on the death?
Yes, we have paid 15 lakhs.
You got 15 lakhs.
They are not satisfied with that payment.
Then what about the service benefits? They will get the service benefits.
No, they are not.
They will get when it just happened in elections just this time. We will dismiss it.
Because he was on duty.
What do you want? Have you quantified the amount that you want? That is 15 lakhs is insufficient. You already paid ex gratia amount.
No,
even for a person who dies in torture and police custody, they're doing 10 lakhs also. You know that?
Because here the case is because it is the
case is what?
Due to
negligence. That law takes its course. You file for damages. You file against that vehicle.
Even the vehicle has no proper document.
That's very good. Then we more culpable.
And moreover, it is on the part of the respondent.
Where is that part, Mr. Abraham? Where they paid ex gratia payment?
They have stated in this paragraph, page 7, para 7.
I understand if that paid you anything. Page 7, no. Where's the document? I don't want to read the pleadings.
That is Annexure 6.
Page?
This is the reply given by this one, page 42, Lordship, last page 42.
Okay. See, as per permissible directions in the Official Election Commission, immediate steps were taken for dealing with the office chief electoral officer to expedite sanction release and ex gratia of 15 lakhs, which was handed over to the family of the Chesan Marak. You already received it.
That is after he received, but they should have taken care where they could have saved the life of that disease, because
it's not it's all in the hands of someone else.
But the fact is reminded because it is on the negligence on the part of the.
We'll dismiss it as speaking order, or you can take other recourse. We can't have fishing expedition. If the fish bites, he's lucky. If it doesn't bite, they don't know.
But one thing can be appreciated, Lordship.
Nothing can be appreciated. You already see ex gratia 15 lakhs, then law will take its course. That's why this court asked whether you work in a sanctioned post. You work in sanctioned post,
Lordship,
very good. Then you get your service benefits.
Just make some observation that maybe some remedy to apply that service benefit at least some.
He will get.
But not that because as of now they have not.
Technical assistance, what grade?
Technical assistant is a great port. If I'm not mistaken, I stand corrected. Technical assistant they have written. Maybe some family members or that service, some kind of observation may be made.
No kind of observation. This the writ petitioners.
Lordship,
stated to be
that I'll withdraw, Lordship. I'll withdraw with liberty to approach the authority, Lordship.
Yes. Mr. P. Sangma, after hearing something, Mr. Sangma, praise him not withdraw the incident petition with liberty to approach to seek other appropriate remedy.
Lordship.
Yes, prayers allowed. Matter stands post withdrawal with liberty as prayed.
Lordship. Much less, Lordship.
Item number 8.
There are two matters together. Yes. Where's Mr. Deb?
8 and 9. I am for 9, Lordship. I am for item number 9. Deb is for item number 8.
I have a sheet. Every man has a sheet. Orders will pass. Where's Mr. Deb? This matter is connected to his matter because the query of the court is why then no provisions obtained. He just went and kept on saying there's a will, and he objected to the mutation. Correct?
Yes, Lordship.
It appears the private party in this matter was supposed to approach the trial court, my lord, for probating the will. Since he has approached 2 times and he has withdrawn also as per his statement, my lord.
No. That's why. Well, Mr. Deb, he always does this disappearing act.
Because here, earlier twice he came to this court, Lordship, the private respondent, my lord. That unprobated.
No, I remember this case. He had filed last. Then when you moved to the other matter,
yes,
you're
Lordship.
the brother. You're two brothers.
Lordship. 3rd petition he has filed.
You're two brothers. He says that he should get everything.
Yes.
That you should not get anything.
Yes. And will was not probated and will was not produced at the time when the matter was heard before the district council. That.
So where's Mr. Deb?
I don't know, my lord.
Most probably he have suppressed some material facts that he have come.
He's not taking instructions also. We'll listen tomorrow.
No, it's not. Up to
we'll dismiss this matter.
As per Friday, like Mr. Deb, he was not well on Friday. I don't know whether he is well.
We'll listen this matter on Wednesday. And due to the absence of Mr. Deb, item number
8.
Yes, this is both these matters on Wednesday.
10.
I'm praying for the matter for listing of matters tomorrow. But on application being made, we've been supplied with the scheme today, my lord. So we are in the course of
applies to you the scheme. I mean, you'll come within the
yes,
consideration.
Yes, my lord. I'll take your lordship to the relevant provision.
Can we give you 1 week's time?
We are filing it in the course of the day, my lord.
Okay, Mr. Estapas submits that the scheme for compassionate appointment of the respondent is being filed in the course of the day, just after 1 week.
11.
Lordship, I humbly pray if the matter may come up at the end of the board.
Who's arguing this matter?
Senior counsel is leading this matter.
Which senior counsel?
And Musica.
Last time you moved this matter.
It was not moved because senior counsel had prayed for time because the records.
See, it's a very short compass.
Lordship.
If suspension pending inquiry, if under 59 Act, then.
Lordship, there was no inquiry in this case.
There's no inquiry at all?
No, Lordship.
There's no inquiry, you're sure?
Lordship.
Is that correct?
They filed 2 show cause. There was a formal hearing. 1 year back, there was a complaint. We took a long time to.
They directed me to file a show cause. I had filed my show cause, and no hearing was heard, and I was not even allowed to participate in the hearing. No opportunity was granted to me, And in violation of Section 6, they
The
are
second
suspended.
proviso, no? Section 6,
That
suspension
will not
pending
apply.
inquiry.
Yes, the judgment of the apex court is there.
Laborious,
Suspension pending inquiry.
laborious money.
No,
Oh, Charleston, yes.
We took one long year to take an action.
Yes.
We could have terminated, we didn't.
No, Mr. Dingdo appeared there, I mean, in that matter.
Suspension pending inquiry, we have decided. We did not take the ultimate decision to terminate.
Lordship, we have other grounds as well. Because as per the customary, Lordship, if it can come at the end of the board.
There are 2 points, Your Lordship.
Okay, let him.
I have some other assignments, Your Lordship.
You see, Mr. Ganta, please, let us have a valuable time at least. Otherwise, we accommodate you so much that, that...
Well.
Hello.
In 12 and 13, these petitioners as contractors had done some work for the PHE department and their payments were outstanding. We just supplied the instructions that we received. Payments are clear.
I'll take instructions from my client. Let the matter come up after a week. If they have received it, then the matter can be closed. We'll close it. See? Check number given, amount given. You've seen. You've given him a copy.
Yes, we've served a copy.
I've seen that. This is matters day after tomorrow to enable Mr. K.C. Gautam to obtain instructions from his clients.
As 12 and 13.
As submissions have been made by the learned CM advocate that the dues claim have since been paid.
14. 14.
The after. Will the one? Yes, Mr. Jha.
My lord, that on the last occasion we have filed that affidavit service of notice with regards to the 8 and 10.
No one's appeared for them.
No.
You file affidavit?
Your Lordship.
Will you sit for hearing then?
No.
Mr. Arja submits that as the respondents 8 and 10 have already been served and no opinion has been made, this matter may be listed for hearing. So, accordingly, list this matter for hearing on so and so.
15.
15 to 21, these are all analogous matter where claim and counterclaim has been made by the petitioner and the private respondent. And my lord has ordered for an inquiry.
Lord, we have filed a miss case. Lord, we have filed a miss case seeking extension of time.
Oh, the same one, is that?
Yes.
What's the name of that famous
V.D.
lady?
Tiwari,
What's that?
Ila Begum. She is the one who created the mass.
The direction was given to
Miss case.
Dr. B.D. Tiwari.
How much time you seek?
B.D. Tiwari. My lord, because a new commissioner secretary is there, my lord.
As per my instruction, my lord, the inquiry has been conducted. Now it is only the inquiry report which
generation of report.
Yes. Now who will file it? It is the previous person who has conducted the inquiry or the present?
The present commissioner secretary will file it.
Yes.
Yes.
The inquiry is not fully completed.
Doesn't matter. And this is a miss case number 64/2023 and WC number 264/2020. This is an application for extension of time for complying with the orders of this court dated 7/2/2023, passed in WC number 264, passed in the present petition, in the connected petition, whereby inquiry had been directed to be conducted by the then Commissioner and Secretary to the County Meghalaya Education Department with regard to the, what's the name of the school?
Lord, this is Khetadua school, my lord.
With regard to the service, appointment and service of the teachers in Khetadua SSA school, UP school, stop.
This is Bagwari, my lord.
Mr. K.B. Barachai government advocate submits that as there's a new incumbent in the Office of Commissioner Secretary and the inquiry is still underway, that appropriate orders be passed for extension and for allowing the report to be filed by the new incumbent. Stop next para. The same not objected to by the other councils appearing in these matters. According, how much time you want?
My lord,
2
we'll
months.
We'll ask for 3 months, my lord. Because in para 3 we have stated, my lord.
Have certain reservation.
One second, my lord. In the para 3 we have stated that the inquiry is at the initial stage, my lord.
No, if you don't give in consideration of the prayer made, stop the respondent, the applicant is allowed.
We had sought for 90 days.
Within 60 days, this can be completed, my lord. Here, my lord.
60 days to complete the inquiry and to file the report. Stop. It is made clear that the responsibility to file the report to the present Commissioner Secretary, Government of Meghalaya. In this case, we stand to dispose of.
22.
These are those land acquisition matters, my lord.
Where's the general?
Your Lordship, I just informed my senior he's in non-lex on court number 1.
What does he want? What's for today?
They were to withdraw those amounts in that 50% deposit. We're not aware if the entire amount has been withdrawn or not.
Has been withdrawn entire amount?
I'm not sure, Your Lordship. I just informed I'll just go in.
After some time?
Other day, minutes.
Listed after 1 week.
Along with the other matters as well, minutes.
Which other matters? This is matter along with other connected matters.
Your Lordship, can this be taken after the board? I'll just inform my senior.
Okay, let him come. All right. After some time.
24.
So, state was required to file our affidavits, my lords.
Yes.
We've already filed it.
Lordship, yes, in their affidavit, Lordship, the Director of School Education is admitting that I got a score highest mark, but only saying is that in the score sheet, all the members have not signed. Then he's asking the members to sign it again, then to just
I don't understand anything. What is the case about?
This is the Lordship. What happened? There was an advertisement for selection of an assistant teacher. I participated. I got a highest mark. And then accordingly, the managing committee have referred the matter for approval to the Director of Education. Then it was just pending. Then for no reason, then we filed this incident affidavit, this writ petition. Now in the affidavit, they are saying since all the members of the managing committee, the panel, they have not given their signature. In that, then they are asking again, may I just you take it to page 10 of their affidavit in opposition, Lordship. They have stated, Lordship. Even they have even annexed.
We'll have it tomorrow for disposal.
Oh. The score sheet was signed. How did the result come out?
So there is a severe lapse, my lords.
Moreover,
then how do you come first?
Because here I come first because they have.
How many panel members were there?
There are 1, 2, 3, 4, 5.
5 panel members and 3 didn't sign.
And we even make a party to the secretary and come secretary of that Rungkungri.
No, this is a serious lapse, Mr. P. Sarma. Because if this is a score sheet, correct?
Lordship.
Yes. And where your marks, where your opinion mark is noted down by all the panel members, correct?
Lordship.
Now, if out of 5 panel members, 3 didn't sign, how will you say it is a valid score sheet then?
But that is not the part on the petitioner, because they should have signed. But others they should have clarified why they is not signed. Nothing was not forthcoming. But the director is only asking, sending back in that letter. Next they're saying on that there is written that in this connection this court should.
Not they won't retain it.
Of course, Your Lordship, but it's not on the mistake on the part of the petitioner.
And Lordship, in
This
view
is from managing committee, the 5 who interviewed you, correct?
Yes, Lordship.
Yes.
And the managing committee is not before Lordships. This case is proceeding ex parte against them.
They already they've been served.
They've been served. It is reflected in the order
they
also.
not appeared.
They've not appeared.
They didn't appear.
And it's proceeding ex parte.
So, Lordship, as per this letter, they're sending back the letter. We can.
They should send it back and let them send it back.
Let them get signed.
There is in fact an instructions of Lordship will find at page 11. Letter dated 25th of July 22.
25th of July.
Page 11 of the affidavit, my lords.
Yes. Oh, now you're in trouble, Mr. Samar.
So this is not challenged.
You seen this one?
Yes, Lordship, I've seen, but
that means that the earlier selection was something wrong with it.
Lordship.
See, what they've done is that you've seen this one.
Yes,
what do you have to say about this? That is said that re-advertise the post.
Lordship, I will just file a small short rejoinder.
Affidavit. The only thing is that rejoinder will not work because this is now that means the entire selection process has been disregarded.
Lordship.
They have not set aside per se, but disregarded. They have said that the earlier selection, all the panel members then signed. Out of 5, only 2 signed. So the score sheet cannot be accepted. So you cannot be appointed on basis, cannot approve your appointment with the score sheet. And now they've directed for readvertisement of that post.
I'm challenging Your Lordship. I will withdraw this petition and will file.
Yes, you can't. If the selection, whatever, if they've directed for back to the planning committee to consider it, then how can they direct for readvertisement?
I was just asking my friend to go through my affidavit before he wanted to argue.
Right, take down Mr. P.D. Sangma submitted due to the new development, namely the letter dated 25th July 2022, whereby the state respondents have directed for readvertisement of the post to which he alleges he had qualified. Not that he submits he had qualified. Stop, he prays and leave it out. To withdraw this petition
and file afresh.
To file afresh, sealing the said letter. Prayers allowed. Petitions close or withdrawal with liberty to file afresh.
I'll leave it.
You have to challenge that.
Lordship.
22.
Must bless Lordship.
Lordship, this item 22 and 26, 27, these 3 items are already admitted. The records are required to be summoned now.
No, but
payment is
you said records can't be called because you're still withdrawing the money. Last time you said that the money is still in the process of being disbursed.
No, everybody has got the money.
Okay.
Item 22, 26, 27, these 3 appeals are admitted.
27. Yes, then we have to make paper book and everything. Let the rewards come first. Item 22, Learned Senior Counsel, Mr. B.K. Jindal, Learned Senior Counsel, submits that the dispersal of the compensation amount in these 3 appeals has since been completed. Stop. Next paragraph. Accordingly, call for the records from the Special Judicial Officer, Ribhai District Nongpo, of the connected of the appeals.
I'm taking submission. 26, 27, yes. Same order. And so far, Your Lordship,
list after, 1 second, list after receipt of records, 22, 27, yes.
Yes. So far, item 23 is concerned, Your Lordship. I have filed a counter appeal, a counter claim under Order 41, and there is a delay of 561 days. So, notice is required to be issued.
Notice to
the Your Lordship, they are not accept because it has to go first to the collector.
Okay. Where's that miss case?
Miss case is
number 1.
Yes, Lordship. Number 1 of 22. Marvelous same and 46 others.
MMCRA, PPL.
This we received, right? 3016. We filed Hazira.
Combination, yes. Cross appeal number, miss case nahi, in bracket or cross appeal. Cross appeal. Number 1 2023. You filed 3 cross appeals.
Yes, yes, Lordship. Not cross appeal, cross objection.
Cross objection. Yes.
Under Order 41, Rule 20, I think.
Yes.
20, huh? 22.
Yes, this is an application. This is cross appeal, miss case arising out of FA number 1 of 2022. Correct.
Yes.
Yes, this is an application under Section 5 of the Litigation Act for condoning the delay of 51 days and filing the needed cross appeal by the applicants stroke cross objectors under Order 41 Rule 22 of the CPC against the judgment order and decree dated 17/3/2020 passed by the Court of the Special Judicial Officer, Riboy District, in reference within bracket REF LA case number 122 2015 and reference LA case number 8 of 2003. The early one thought new number. This is an old number. The other one's a new number. Stop. Next for issue notice. Steps will be taken within 3 days.
By registered post.
By registered post.
Lordship, here.
This thereafter. This after 3 weeks. Yes.
Yeah, in item 22 there is one miss case, MC4 of 2020.
We already passed orders just now. 22.
MC4
no,
of
22. We already passed orders. 22 just now. We already passed orders for calling of records. We've already passed 22, 26, 27 orders have already been passed.
No, Lordship, in item 22 there is a miscellaneous case MCFA 4 of 2022, which is a petition for amendment of the memo of appeal filed by them.
You filed an application.
Lordship, we had.
That's not been taken up.
Lordships had heard it, but thereafter the matter was not finalized.
So this is require a hearing. I will file a show cause also in between. MC4.
1 second. Item 22. Once a connected matter, the records get very jumbled up. Miss case number?
MCFA 4 of 2022.
Yes. This file since October last year.
Lordship. This was heard along with the application challenging the maintainability of my appeal.
The appeal was admitted.
Lordships had concluded that it was best to first allow and admit the appeal, and the amendment application would be taken up later when it was heard together.
Yes.
This may be posted for hearing. In the meanwhile, if need be, I'll file a show cause.
Case number 4 of 2022. But then this is after record comes, so it doesn't matter. In FA number 1 2022, there's an application for amendment of the memo of appeal filed by the collector, Riboy District, as petitioner. Stop. Next paragraph. Mr. B.K. Jindal, learned counsel for the respondents, prays that be allowed to file some objection to the amendments sought in the memo of appeal. Prayer is allowed. Is together with main case after records received. Objections to be filed in the meanwhile.
Item 35, 36, Your Lordship, are also connected. 35, 36. These are separate appeals filed by me.
35 and 36.
35, 36, and there is an application for condonation of delay. Last time we moved this application. Since Your Lordship has already condoned in other cases, so these two applications be also on identical grounds only. 35 MC 8 and 36 MC9.
MC8.
MC8.
Where's the order where we had condoned the delay?
That is in
the other
cases,
matters.
Other matters.
That way you said the hell that reference has to be answered, doesn't matter. Once a reference is made, unless it's answered, that I mean there's a question of delay in
No question of delay.
where in which judgment?
In his case also, in my Armstrong case also, similar order was passed, and because here item 22, 23 also, which were not 23, 26, 27. Also there was a delay, which was condoned.
Item 26, 27.
26 and 27.
Too much reports here. Yes. 36, 27.
In this case, tomorrow on item number 26, we have the order.
Order come order. Order mean order.
Condonation.
Yes. Anyway, okay. Miss Case, take down the item 35 first. How much delay?
300 days. Delay is explained in para 3.
Yeah, 35, 300 days. Yes. This is an application, Miss Case number 8 of 2023, 8 of 2023, item 35. This is an application for condonation of delay of 300 days in filing the related first appeal by the applicant appellant under the Land Acquisition Act. Stop. Against the judgment order dated, same order, 17/3/2020, passed in reference LA case number 122/2015 bracket new and reference LA case number 8003 bracket old. Stop. The delay of 300 days on the good grounds shown in para 3 is hereby condoned. Accordingly, Mr. Applicant stands closed and is pulled out, appeal to come up for admission. Similar order in the other matter. Only check the number.
37. Highly obliged.
25.
In this matter, we have filed an affidavit on behalf of respondent number 4, my lord. This will cover, my lord, the respondent number 1, 2, and 3, my lord. Basically, 1, 2, and 3 will rely on the affidavit.
What's the matter about?
This is a matter relating to a government corporation, my lord. The corporation was wound up and the employees were given the golden handshake. But whatever was due to them was not paid.
Which corporation is this?
This is Meghalaya Electronic MEDCL. It's a.
You want to file a jointer?
I'll be filing. 3 weeks may be given.
As prayed by Mr. K. Gautam, no, first take down Mr. B. Bhattacharya AG submits that the affidavit filed on behalf of respondent number 5. 4, shall suffice with regard to the respondent 1, 2, and 3. Who's appearing for number 5 and 6? You're 4? 5 and 6 is what?
MEDCL and MIDC.
Yes, you already filed the affidavit.
They filed their affidavits.
Yes, I think will suffice for other respondent 1, 2, and 3. I'm sorry, your name? I am MS. I am present behalf 5 and 6 and submits that the affidavits on behalf of these respondents have also been filed. Next para, Mr. K. Gautam prays for and is allowed 3 weeks time to file rejoinder.
Seek
Affidavits.
Advice on file.
If so advised. Yes.
28. 28.
Yes. But like election matter. You have effected notice on 567.
Let's hear the matters listed today because there is an.
You know, you allowed a postal return of postal authority regarding.
We've taken fresh steps, Village.
You're appearing for 567.
For respondent number 1, Your Lordship.
No, one. No, what about 5, 6, and 7? One well and good.
No.
But when did he take steps, Mr. Paul? But that last time it came 11th.
18.5, my lords.
Limitation.
Let's hear 2 miscellaneous applications have now been filed. One by the election commission and one by the
respondent number 1.
Respondent number 1, my lords.
For striking of pleadings?
No, my lords.
Not maintainable.
They challenge they're
on ground
challenging
of
the issue
limitation.
on the that it has been allegedly
Beyond
filed on the 46th
45 days.
day.
Within
It's filed on the
45
46
days. According to the Act, Your Lordship, it should be filed within 45 days. And
What happens if there is a holiday in the middle?
But holiday and all.
I mean, in the end, sorry.
It governed by the Limitation Act, but there is no provision for Limitation Act.
There's
to
no
apply.
provision for condemnation.
Condonation.
Yes.
And this is a complete court and a special law, Your Lordship.
Even be that as it may,
And various
the
Supreme
General
Court
Clauses
has
Acts,
rules.
the provisions of the General Clauses Act will apply.
General Clauses Act also is not applicable in this case, Your Lordship.
No, because the
Various Supreme Court has ruled.
Limitation, yes.
Yeah, limitation, yes.
Limitation, yes. General Clauses Act would automatically come into play, my lords, if the 45th day ends on a holiday. So then it would be, my lords, the 45th day will be counted on the next working day.
You have
But this one, it is a complete court and special law, Your Lordship.
No, yes, no, we understand that. It's a special law, a complete code. There's no scope for condemnation. But his submission is that on the 45th day, it was a holiday. So what happens? Will that day be counted? Will that day be counted, or as per general, will that day be counted, or like the 46th day will be like be counted as 45?
Within 45 days is inclusive, Your Lordship.
Whether it's even the last day is holiday
Yes,
also?
yes. Yes,
You have any authority?
Yeah, I have Supreme Court rulings, Your Lordship.
Before we get into that, my lords, the first issue is, my lords, whether this application in the present form could be filed by the.
Secondly, Your Lordship.
How would you haven't seen the application?
If your lordships kindly have the application, my lords, because under the rules, my lords, they would have to first seek leave from this honorable court to file any application.
You have not taken leave.
There is no leave. So this application has to be thrown out in the first place because of that, my lords. So unless your lordships grant them leave to file a miscellaneous application, my lords, they cannot file a miscellaneous application.
When did you file it, Mrs. Sangma?
We've got a copy on the 10th of May 2023.
Yeah, on that day, sir.
You filed it on 10th without seeking leave of the court.
Balance.
Yes, Your Lordship.
How is that possible?
We have received the notice and hence we have filed, Your Lordship.
Then that we can overlook. We can do application. Application.
The second thing, Your Lordship, the party from whom relief is to be sought is not made a party in this petition, Your Lordship, like returning officer, chief electoral
Why
officer.
this is under is for improper affidavit?
No, my lords.
This is corrupt
This
practice.
pertains to, my lords, the malfunctioning of a certain EVM, where, my lords, the results of the mock poll were not deleted.
Okay.
And it is our case, my lords, that had materially altered the figures that were there at the time of final counting. This issue would be covered by Jyoti Basu, my lords. If your lordship so allow, I can file a short reply, my lords. But the issue is, my lords, that I will raise the preliminary issue of objection with regard to this miscase because it has been filed without any liberty. So either they have the option of, my lords, withdrawing it and filing it afresh after seeking leave from your lordships, or, my lords, I would have to raise the preliminary issue of not seeking leave.
It is up to you, Lordship.
Up to me, up to the court,
your
not to me.
wisdom.
I'm just sitting in this chair, Mr. Sangma. It's not up to me.
Up to the court, your Lordship.
No. I can represent you that. I thought it was an application of the Order 6 Rule 16. Anyway, the first time I've seen it. See, if you want to lengthen the process, then
your Lordship, lengthening the process
serves the purpose of the respondents.
Serves
the purpose of the respondents. You see, that's the thing, because we are under a mandate to complete the election petition within a certain period, which is never possible. And most cases that, by the time the results, the election petition, it becomes fructuous or decided maybe 4 years, 9 months, after it was filed.
Operation successful, my lord. The patient is dead by then.
They have not chosen to file before
with
that.
regard to the acceptance of affidavits, there have been some cases, even Arunachal Pradesh now, where they've been disqualified. I mean, election set aside.
Because here, my lords, the election commission itself has taken action against the presiding officer. Now, there, my lords, proceedings have been drawn up as
but since your case stands a different footing, we'll have to examine what is the effect of of that mock trial, whether those votes went into your main line or mainstream or whatever.
Naturally, my lords, because the handbook provides, my lords, that the results of the mock poll have to be deleted prior to the date of the polling. So it has to be a fresh EVM.
So the fact that the mock poll, the entries in the mock poll were not deleted is a fact.
It is on record. It is on record, my lords. The election commission, as a matter of fact, issues notice against the electoral officer saying that why weren't they deleted and why action should not be taken against him.
Okay.
Your Lordship, I don't want to comment on those.
Yes?
I don't want to comment on those before, but it is I strictly maintain on the maintainability, Your Lordship.
You want first strike by maintainability?
Yes.
So you don't have to go anywhere else?
Yes. It is not maintainable.
Your Lordship may hear us.
Let us hear maintainable then. If you do away with the yes, though no leave to file the objection.
That risk, my lords, you'll have to take.
Has been taken. Stop to file the no notice taken from the court to file the objection. The set applications taken on board, whereby the challenge to limitation has been put up by the respondent number 1.
Yes, Your Lordship.
This miscase EP number 2 of 2023, election petition number 6, 2023. Yes. Yes. You start. Maybe anything that you want.
The fact is that, Your Lordship, the result of declaration of this result was announced on the 2nd of March. And the limitation period starts from the 3rd. And 45 days end on 16th of April.
You are the return candidate?
Return candidate.
Remington Gabble Moment. You are
yes.
Remington Gabble. Okay. Yes. Now the results are declared on the 2nd.
2nd.
Of 2/2/2023, correct?
Yeah.
Okay, then?
2/3.
2/3 or 2/2? 2/3. Okay, yes.
And the limitation start from the 3rd.
Yes, okay.
And it ended on 16th.
Yes.
It was Sunday.
Yes.
And the election petition was filed on the 17th and delayed by 1 day.
Yes. 16, it ends on 16 April.
16 April. And delayed by 1 day, Your Lordship.
Yes.
And in this meeting, I want to refer to the Supreme Court judgment order It was said in the AIR, but I tried to Xerox that one, but it is not clear, Your Lordship. But
now everything's online, Mr. Sangma. You can download anything.
Yeah, but I am not getting that AIR 1974. So I have got this SEC 1974, Volume 2, SEC 133.
You didn't give us the books. 1974? Volume?
Volume 2, Your Lordship.
Yes.
Page 133. Hukum Deb Naran Yadav.
Para?
Para 17, 19, 20, 22, 23, 24, 25, and 26, Your Lordship.
That's the whole judgment only. 17?
17, 19,
19,
20.
Show the code. Where is that finding?
Page 146, Your Lordship.
Yes.
If you allow me to read, I will
Please,
like
please.
to. Though Section 29(2) of the Limitation Act has been made applicable to appeal, both under the Act as well as under the Code of Criminal Procedure, no case has been brought to our notice where Section 29(2) has been made applicable to an election petition file. Under Section 81 of the Act, by virtue of which either Section 5 or 12 of the Limitation Act has been attracted. Even assuming that while a period of limitation has not been fixed for election petition in the schedule of the Limitation Act, which is different from the fixed under Section 81 of the Act, Section 29(2) would be attracted, and what we have to determine is whether the provision of this section are expressly excluded in the case of an election petition. It is contended before us that the word expressly excluded would mean that there must be an express reference made in the special law or local law to the specific provision of the Limitation Act. Of course, the operation is to be excluded. As usual, the meaning given in the dictionary has been relied upon, but what we have to see is whether the scheme of the special law, that is, this case, the Act, and the nature of the remedy provided herein, are such as legislator intended to be complete court by itself, which alone should govern the separate matter provided by it. If on an examination of the relevant provision, it is clear that the provisions of the Limitation Act are necessarily excluded, then the benefit conferred therein cannot be called in aid to supplement the provision of the Act.
See, the thing is that I think their case is that it's not there's no quarrel that Limitation Act doesn't apply.
Does not
No, it doesn't apply. He also accepts that position.
Yeah.
That doesn't apply. Limitation Act, like we all understand, apply to suits and civil proceedings and so on and so forth. That is not what the only point here to decide in your challenge is that they say that 45th day was a Sunday.
Yeah.
So if you wanted to file the election petition 45th day, it's not possible. Though Section 81 allow that. 45 days, correct?
45 days
Yes.
allowed.
He could not file it on the 45th day because of the Sunday, so he filed on 46th day.
And
now,
in
what that's the only thing this court decide here, whether the 46th day can be taken to be the 45th day within the meaning of Section 81.
According to this judgment, Your Lordship.
No judgment. See, these judgments, we have no quarrel. The Limitation Act, that Representative People's Act, is a special act, is a self-contained code. That there's no quarrel. That limitation does not apply. There's no provision of condemnation. It's fine. Like court repeating that Limitation Act applies to civil proceedings, suits, and so on and so forth, and whatever is there in the schedule also. For the time allowed.
It is not
applicable. So Limitation Act, that the Limitation Act applies and does not apply, there's no dispute. Only now you have to show that 46th day, because there they say it was a Sunday. That was, which day was that? That was 16 April was a Sunday.
Sunday.
Where's April? Okay. Yes, it was Sunday. You have to satisfy the court. You have to satisfy the court on your objection that day was the 45th day.
Your Lordship, if we go by Section 81, they should have provided in that act itself. After a provision has to be provided in Section 81, but there is no provision in the 81 of the act.
Now, in the case of 45th day as a holiday, the next day will be.
It is inclusive.
So you mean to say that
I mean that it should be inclusive, even Saturday, Sunday, and 45 has been said. Why they have not chosen to file before that? Though very clearly they know it before that. So in my humble submission, Your Lordship, Sunday also inclusive, Saturday also inclusive. That is my humble submission, Your Lordship. And this judgment is very clear. Not only this.
Show another judgment.
Even in this 1999, Your Lordship, judgment 1999.
I think Mr. Paul, you better file a small written objection. It'll go on record. That if civil proceedings demands that.
Then, your Lordships will also consider whether your Lordships will entertain this application in view of the specific bar. We are getting into technicalities, I don't have any option but to.
Yes, no, you please, okay, let him finish his
let him.
Yes.
In this 99 SEC, Your Lordship.
Volume?
99 SEC. Page 2, Your Lordship. Page 534. 1, 2, 3, 4, 5, 6. In 7 lines. Since it is a common ground that election petition in the instant case has been filed 1 week after the expiry of period of 45 days, it was clearly barred by time. The High Court was, under the circumstances, fully justified in dismissing the election petition on that ground. It is 1 week or 1 hour or 1 day fall on the same footing, Your Lordship.
Now, actually, they refer to a calendar of summer vacations.
Yeah.
Yes. Mr. Paul, you're relying on Section 10 of General Police Act.
What is the citation?
99.
Yes, Mr. Sama.
Yes, Your Lordship, and that Section 10 of the General Process Act has been dealt with under this 3 Supreme Court judgment, Your Lordship. And in this one, it cannot help to apply that Section 10 of General Process Act.
Why?
It is very, very clear.
Why?
The reason is that there is no specific.
Because if the Limitation Act doesn't apply, then you have to bring in the General Process Act.
According to
Suppose
this judgment, it is
yes?
not that one. Sir. So this petition is not maintained.
What judgment is Section 10 applicable? Show the judgment.
99.8.
Yeah, 1999.
532.
Paragraph?
Paragraph 9.
Yes. The proviso to Section 10 make the provision of Section 9 inapplicable to case where the Indian limitation apply. Since the Indian limitation does not apply to election petition filed by the Act, Section 10 of the General Process Act, in terms which apply to filing election petition also, according to Section Supra, an act should be considered to have been done within a prescribed period. It is done on the next day on which the court or office is open. The application of Section 10 Supra would, however, depend on the fact of each case and the manner in which the High Court transacts its business during the period distinct.
No, that means
suppose, and I would like to the
suppose one thing, Mr. Sama. Listen, suppose now you see, okay, some of their vacations, okay?
Yes.
The vacations for 1 week, okay? Vacation of 1 week, but then you file the application after the vacation gets over. But during the vacation, the registry is open, you can file. So where does that leave us?
For other cases, for civil and criminal, it applies, Your Lordship. But for general, for this act, which is a complete court and a special law.
No, but general clause will apply where Limitation Act doesn't apply, then you can bring in the provision of general clauses.
It is not in this special law, Your Lordship.
No, I don't think I agree with your submission, because if it's looking at a case-to-case basis,
yeah,
that's the only thing. If we look generally, yes, suppose it's open for, the court has these holidays, or the rules of the High Court provide such, that the registry is open for filing. But then you didn't file, and you come after summer vacation ends the next day, and you file the application, maybe then your application will not be maintainable. But then if it's a Sunday and the registry is closed, tricky question.
This has been dealt in this various judgment of Supreme Court, but exactly now to find out that section, I have read also. But
no, kindly assist the court to show that it is, watertight. You cannot, no matter what circumstances, Sunday, Monday, whatever.
You can give me another day to support that one, Your Lordship.
You have the judgment, do you not have the judgment with you now?
I have judgment, but it is too long, 20 pages, and I forgot to note down that point.
Heard you for on. Anyway, Mr. Paul.
My humble submission, Mullad's para 9 of this 1999 judgments, Mullad's actually settles matters.
It is,
they
have discussed only.
Me to just read para 9 again.
But that is discussion, Your Lordship.
No, what he says that he has a overlapping decision that that seals the deal. That's why he wants to place
some other judgment. I was thinking about since 1999. I was
no, because I know they're going to rely on Section 10, but I think that the manner of applicability is Section 10. In which case, how can you apply it? That's all.
Yeah.
So if the courts interpret that, and see, we see in this case, yes, Sunday going to have been filed. So then that's 46 days. It's not a case of 1 week. It's a 1 day delay.
My lords, in my humble
there's no delay.
There is no delay.
Yes, Mr. L.M. Sangma, Miss case EP number 2, so in election, so. In the course of submissions, Mr. L.M. Sangma, please, he will be given some further time to bring up authorities in support of his application objecting to the on limitation. Yes. When should be listed? Will they have to after 3 weeks?
Your lordships are not available.
Won't be here for some time. But you prepare, but kindly do one thing. Just assist the court. Can you just give the citation and also the you can just mark on your own judgment which part you want to read.
Yes, only on that point.
Only one small prayer. Your lordships may also note, indicate in the order, that we have challenged the very maintainability of this application before your lordships.
Yes, yes. Please that so. Or you can take recourse, you can take leave of the court again. Anyway, but we're not advising.
If you have allowed that one.
No, we have to note that in the same order of thought, taken on board, but then it is also noted here in that Mr. K. Policy Council on behalf of election petitioner has raised objections with regard to the maintainability of the application, challenging the application, challenging the miss case itself. So list after 3 weeks and so on.
After 3. So we may be permitted to file a short reply in the meantime.
29.
Reply, if any, may be filed by the. You can take that objection also to the maintainability of the miss case itself.
Highly obliged, Your Lordship.
You have filed an application.
This Lordship, in fact, we have filed 6 applications. But for the sake of convenience, if Lordship start from miss case item number 30, that is miss case number 3, and we'll come back to 29.
Number?
30.
So you're moving 29 or 30?
30.
You won't have objections. I don't think I have objections. Yes.
Simple application.
Well, since 29 melodies, I have an objection.
I'll come to that if Lordship permits.
No, which one do you don't have objections? Just give the numbers.
Perhaps 30, 31,
31,
33, and 34 is a similar application.
Okay. Just.
The Chief Election Commissioner is not made party in the main petition, so whether they can file the miscase.
Intervening, we are filing intervening, seeking this limited direction.
Have you filed the intervening application? It's already on record.
It is
part of the same application, under order 128.
Okay,
if I may pray, if we can go in seriatim, because otherwise it's just going to create a lot of confusion.
Yes. Okay.
29 would be the first application.
But may I start from 29 then?
Yes, at 29.
29.
Well, it's item 29, I again have that preliminary objection before your lordships, that without leave this application could not have been filed before your lordships.
We can see application. We are moving this application before this court under Order 1 Rule 8 AM. Seeking limited intervention. Because we are not a party there.
Yes.
We are not a party there.
But can you club 2 prayers in one petition?
My Lord, that is when we see the limited prayer we made.
Yes.
Unlimited prayer, my Lord. When we see Order 1 Rule 8 AM, CPC.
Yes.
If Lordship permit me to read out, my Lord. Power of court to permit a person or both their persons to represent opinion or to take part in the proceedings. While trying a suit,
that no quarrel with that, Mr. Chari. So, court they can allow you to take part, but whether you can doesn't this deserve a subsequent application on your intervening application being allowed first and being a party? You see that's a technicality which we have to overcome. Because the thing is that Order 1 Rule 8 well and good. We have to, allow you to intervene. Correct. Now you've intervened, we'll have to make your party there. And then after you've made a formal party, then you file an application for, taking out the machines. That's it.
Well, this is a prayer that here, if I go and understand probably this order 8.1, it is not necessary that I should become a party in the suit. Depends on the matter, depends on the prayer.
See, we're not asking you to file, to give your opinion on a question of law. Another one is. And only the court, the thing is that, see, to take part in proceedings, now in this case, what will the court do? Okay, order 108A has been filed to allow you to intervene and take part in the proceedings, correct? Now, take part in proceedings, usually you implead or intervene, suppose you want to address a question of law or some other important aspect. Then that's one part. Second part of order 108A is, what does the court deem fit and proper, to what extent to allow you to intervene in the matter? That is the qualifying feature of 108 also. Now, if this court feels that yes, you can intervene because you have a prayer, that prayer comes subsequent another application. Then we say yes, they have intervened here, voicing these concerns that this machine is necessary. So for that purpose, we allow the chief electoral officer to intervene in the matter. Let them file a appropriate application for taking out those machines. I think that's the proper course.
In that case, may I pray? Matter may come up on Friday or Thursday.
See, we don't want to be burdened with technicalities, but then once you're doing election matter is hyper technical. See, on even a small technicality, your case can go or your case can stand. Yes. Yes, please.
But the intervention we are seeking is very limited, which is part of the prayer in this application also, the second prayer, my lord. We are not praying for impleadment.
Just intervening, not impleadment.
Intervening only for the purpose of the second prayer, my lord, to kindly release the EVMs, my lord. That is a limited intervention. My lord, these matters, my lord, time is very crucial, my lord, because we have been instructed by the Election Commission to ensure that these EVMs, they reach the designated warehouse at Hyderabad on or before 27th of this month, my lord. So time is of an essence, my lord. We are not seeking for impleadment. We are only seeking for limited intervention with respect to the second prayer to kindly release.
In item 30 are parties.
Item 30 we are parties, my lord. Item 31 we are not parties again. Item 32 we are parties. Item 33 we are parties.
You made similar prayers on all these.
Similar prayers, my lord. Exactly. The only difference with item 29 is, my lord, the issue on 29 is with respect to one particular polling station, that is polling station number 52, out of a total of 60 polling stations. So the allegations in the election petition is that
how they all under lock and key together, right? All these
yes.
EVMs now.
Yes.
How do you know which one was used in 52? It's designated.
We have the ID, my lord. I've indicated in the application itself, my lord. There is a ballot unit ID, controlling unit ID, and VVPAT ID. So in polling station number 52, this particular.
Where is that in annexure? Where is that this particular machine has been sealed and it's been kept somewhere?
I've made the statement, my lord, at para 6 or para 5 onwards, my lord. Oh, sorry, my lord, para 3. Para 3, page 6.
How many EVMs are used in polling station number 52?
One, my lord. One set.
Only one EVM was used.
One set is what is indicated, my lord. So there were 60 polling stations, and in one particular polling station, which is subject matter in this election petition, is polling station number 52. And this is the ID, my lord, I have provided.
Okay.
So with respect to the remaining 59 polling stations, my lord, there's no issue. There's no averments in the election petition also, my lord. So, my lord, my prayer is, if only this particular machine, at prayer number 2, my lord, prayer number 3, my lord, to retain this particular EVM with ID so and so, and kindly release the remaining.
Yes. We'll allow Mr. Paul. I don't think it should be substantially affect the. You have objections?
Objections will
to releasing this the other EVMs which are not involved in the polling station.
Well, it's Not to that extent, but again, my lords, the technical issue comes up that, my lords, somebody who is not a party in these proceedings, without first, my lords, maintaining an application before your lordships, my lords, seeking impleadment or otherwise, whether they can, an application seeking substantive relief can be filed by them.
We need not be.
No, it need not, because like earlier matters on earlier occasions also chief electoral officers not made a party also.
Well, they're not required. They're not required because
They're
I'm not
required.
taking any relief from them.
Not required.
But the issue here, my lords, is that, my lords, whether this application could have been filed in this manner. So that your lordships would have to decide.
If we seek for impleadment, my lord, then subsequently we'll have to come for striking off, my lord. So therefore, I've come under Order 1, Rule 8A, my lord, for a limited prayer, my lord, which is prayer number 3.
Yes, take down. This is an application under Order 1, Rule 8A of the CPC for limited intervention. With an additional prayer for clarification that where's your prayer for return?
7 onwards, no? Prayer number 1 is for limited intervention. Prayer number 2 is not for clarification.
Well, it's
the prayer also say it.
Page 8.
See, page allowing limited intervention, okay? Then you didn't say return, you didn't say for release.
Prayer number 3. Direct for retaining
and
only
release the
one of
remaining
the EVMs.
Prayer 3, my lords, it is there.
Okay.
Subsequent.
Yes.
If your lordships are disposing of the matter, my lords, my lords may only just take note of my objection, my lords, because then subsequently, my lords, in the other miscellaneous application, this issue would come up. Would your lordships, my lords, want me to place the relevant law on with regard to that?
We have objection to this.
Well, I have an objection to maintaining of a miscellaneous application in this way. It cannot be done, my lords.
You place the law?
Well, I'll just take your lordships first. We first have to place a reference to, the Northeastern Areas Reorganization Act of 2012, my lords. This was placed before your lordships on the last day, my lords, for the purposes of showing, my lords, that the rules for trial of election petitions, insofar as they are framed by the Guwahati High Court, my lords, are made applicable to this court, since no separate rules are framed.
It's okay, you just read it out. Well,
then I
what
can
I
take
could
your
say.
lordship straight to the rules, my lords. In Rule 10, my lords, is the specific rule, my lords.
No, read it out, yes.
Well, it says that all interlocutory petitions should bear a court fee stamp of ₹6 thereon and may be filed before the judge with the permission of his lordships. So, to that extent, my lords, what has been this application was filed by them on 18/5/2023. This was what was given to me, and the order sheet before that it would reflect, lordships, that the matter was last listed on 11/5/2023.
On the main, in the main matter.
In the main matter, my lords.
So it's fine intervening period without any application.
This is coming for the first time today.
No, you correct it because he's right. Because like, we have to adopt the rules of Guwahati High Court.
Because these are rules of procedure, my lords.
This matter is coming up for the first time today. This particular application.
So, what had to be done, my lords, is first, my lords, a mention had to be made before your lordships that we want to, my lords, seek leave for filing an application, and then an
Like
application.
Mr. Sangma's also, same thing.
Because these are rules of procedure, my lords. And your lordships are aware, my lords, Guwahati High Court has held that these procedures are mandatory. So, unless they are complied with.
Because the election petitions we have to, that's why the first time when he came, while I asked, please file Hasiras, please, file your presence. It's not like a writ proceeding. Your presence should be noted. We are maintaining a separate file for every application, even for adjournment. Also, you have to file an application. That is, that is the rules of procedure for election petitions.
This application itself is in the nature of obtaining leave of your lordship.
No, you can't club 3 prayers then in one application. You can't have an application seeking leave, an application under Order 1 Rule 8 and another under 151. You can say like for release of the machines.
No substantive relief can be first, my lords, prayer can be made unless your lordships grant leave.
You kindly check up and we correct that.
With due respect,
yes,
the urgency is there. Lordship may either come up day after tomorrow. We'll move the
file it by tomorrow. The moment you file it.
I have no objection.
Yes. Parties, Mr. H.S. Sangreso would also pray that they may be allowed one day's time to correct the process of based on time to file the corporate applications. Yes.
Other items, my lord, we are a party.
Can Mali even move to the rules?
In this, I have no objection, my lord. For item number 30, I have no objection. For releasing of the EVMs.
Are you party here?
We are a party. We are a party.
You have not filed an application, but for leave to file anyway.
Since we are already a party.
Yes. Take down this application under 151 CPC for release of the EVM dash VVPAT machines from the strong room for further use and transportation by the Chief Electoral Officer, the applicant herein, applicant number 1 herein. Mr. H.S. Hariso submits that these as the EVMs are necessary for what? To be transported back to Hyderabad.
Hyderabad, so that the clearance would be there for next general election
for further use in other elections. Mr. S. D. Mr. S. D. Counsel for the election petitioner has no objection, as the EVM and the EVMs are not subject matter issue in the application. According prayer is allowed. Yes, but said machines to be released into the custody of the respondent number 1 for
another miscase number 4. Similar prayer we are making, my lord.
That one?
Which item?
Miscase number 4.
Item number?
Item number 30.
Just same order.
Item number?
30.
Who's appearing there?
Item number 31.
Who's appearing there?
But we have served copy to my other friend, to the petitioner.
31.
Item number 31.
For 31, we have no objection.
Same order then. Just note down Mr. Kriyam's name.
But Lordship, here also they never took leave of the court, and service a copy also was never served to us.
You
Lordship.
never serve a copy?
No,
What
Lordship.
is this?
In both in 30 also, Lordship, I was not wondering, that's why. Copies were never served to us, Lordship.
Who's election petitioner?
But they are saying and 6 others.
They are the
This is his
respondents.
case, election petitioner.
Yes,
You are
they
appearing
the
for other respondents.
Yes.
They are the return candidates.
Lordship, in item 31, we are having the same objections as Mr. Paul in item 29.
31?
One, yes, in item
You have which
31.
respondent? Who are you?
In
No, who are you?
The return candidate.
copy
No, respondent number. Who are you? No, who are you? In the election petition.
We are the I'm the returning candidate, Lordship.
You return candidate?
Yes, Lordship.
Then you have to correct
Copies
it.
had to be served, Lordship. Leave has
Then you have
never
to correct
been
it.
taken.
Return candidate you didn't give.
In both, Lordship.
Then
in
Mr.
30
Kriyam is
also.
appearing for whom?
He's for petitioner. He's for the petitioner.
Petitioner, you for return. Then they need a copy.
In 30 also, Lordship, we were never served. In 31 also, Lordship.
That was order passed just now.
Yes, Lordship.
You return candidate at 30 also.
Yes, Lordship.
Then strike out an order. Yes, you just correct the proceeding. This all day after tomorrow.
Highly obliged, Lordship.
You can file the same day you're having for leave, your application and everything.
32.
Similar way. They come up with the same thing.
Let them all come up together. Yes.
Between the election commission and the court, my lord, the election petition says that EVMs that the issue involved there is
Doesn't matter.
not the
It's
EVMs.
just correct the procedure.
Mr. Paul's case is different. EVMs is the issue, my lord.
Doesn't matter.
This is a question of procedure.
Procedure, yes.
Because what would happen is subsequently there would be other miscellaneous
When does it
applications filed, and there would have been references made that there was this application filed for limited intervention, your lordships have allowed. So that would, my lords, infringe my rights.
37.
Where's MSP Barasaji?
Lordship, we seek 2 weeks' time. We are not ready with the affidavit because Miss P. Charji's uncle has expired.
Oh, okay. Your name?
Yudhar. Yudhar.
Yudhar. MS Yudhar Vice MSP Barasaji prays funds allowed for the 4 weeks time to file affidavit due to bereavement in her family. Correct? Yes.
38.
My lord, will kindly see the last order, my lord. The lordship took a serious note and asked and directed the respondent to file the affidavit. Till now, my lord, I have not received any affidavit.
But I've received instruction, my lord. I'm praying for 3 days time, my lord.
But the only thing, may I pray your lordships? I think this code will not be available for some time. So if he can file the affidavit, my lord, within 4 days, I will also file the rejoinder.
One thing, you brought on record by affidavit, will change the location, no, for submission only, no?
Submission, my lord. But this is a fact, my lord.
But that's what if that is a fact.
My lord, here there is a lot of problem, my lord. Here what happened, my lord? Petitioner and there is a private respondent, my lord. Petitioner offered a different plot of land, which we found is not suitable. And the private respondent's land was somehow found to be reasonably suitable, my lord, for that purpose. During the pendency of the matter, my lord, the petitioner has gone and offered the same plot of land which the private respondent is having, my lord. So the submission made before lordship that after offer was given by district council, subsequent to order passed by your lordship, my lord, is the same plot of land.
I don't understand. The same plot of land was given to private respondent
and petitioner also.
He was set. You mean to say that in the earlier case, there is private respondent's land, he was settled because it's more suitable. So now petitioner has taken over that land.
That land. So the district council said that this is not going anywhere. What is happening is same land petitioner is offering, private respondent is offering. And the statement made that they will spend a lot of money and
that is not the case. There was a first round of litigation. What happened? They said my land is not suitable. I was not offered. Instead, my lord, the private respondent was offered. I came and challenged. Lordship, after hearing in details, my lord, looking into the record, lordship said no. My land as per the tender condition is all right. They could not have rejected me. Instead, your lordship has set aside the appointment made in favor of that private respondent. Thereafter, the district council, my lord, made a concluded contract with me, offer me the BDO, offer me the settlement. Now, my lord, what happened, your lordship? They said if you can construct a levice and a bigger land, they never said that I am not qualified. If I was not qualified, they should not have settled. And this was decided by the court. They have never preferred an appeal. Now, thereafter, what happened, my lord? When I was expecting that it would, formal order would
come.
Only
one question, Mr. Sen. You went and took over the land of the private respondent, is that correct?
I'll come and explain, my lord. I'll come and explain. It's not the question of private respondent, your lordship. Now, what happened here, your lordships? My lord, they gave me an offer, your lordships. They have made a concluded contract. And after, when I was expecting that order would be passed in my favor, they have cancelled it. And what is the reason for cancellation, lordship will see? Reason for cancellation, a pleadant notice was served by the private respondent whose, my lord, settlement was cancelled by your lordships without giving me an opportunity. So that's how I came before your lordships. Now, lordship, while my lord admitting this case, further directed that they will not issue any tender. So in the meantime, just to frustrate it, what happened, my lord, they have shifted from the original place where they were running it departmentally to some other place, my lord, 5 kilometers away, to a place called Claythisi. Now, my lord, coming to the land, your lordships. What is the land, your lordship? There was a plot of land from where district council was running it departmentally. Now, they obtained it on a lease from a private party. Now, somehow, I don't know, my lord, even the earlier round of litigation, the private respondent whose favor it was given, he also somehow took it on lease and offered that in the
initial first round.
Initial first round of litigation, my lord. And then they raised the question that my land falls on the left hand, not on the left hand side, on the right hand side. Lordship had rejected all those contentions. So when they ultimately, my lord, finally make the offer and they asked me to get a bigger plot of land, my lord, I approached, my lord, the same person, lady, from whose land, my lord, district council.
Too complicated. Yes,
that's why I'm saying, my lord, let them file the affidavit, your lordship, in 3-4 days, and I will file a reply.
Now you see what is happening, Mr. Sen, is that we are slowly, approaching to the realm of disputed facts. Then will not be able to make any kind of conclusive finding. We can, on any on your competing rights. That's the problem. And if it was correct that you've taken your land now.
Same land. No, my lord, is once the concluded contract is made, your lord, I'll show your lordship how it is a concluded contract. Once the concluded contract is made, they could not have been cancelled.
Court give you protection because a concluded contract is there without notice to you, it was cancelled, right?
That also had the
on
instance
a
of-
legal notice, fine. Now court gives protection that extend the no fresh tender, that the matter proceeds. Now what they've done is that now they've gone and shifted the whole revenue station to another place. Number one, if that is correct, also we have not seen any materials to show that this is the
will come
particular
in their
is the same one that's gone there. Number one, and number two, not the other ground is that you were anyway file it within 2 days.
And then I will file my reply.
Little longer.
4 days, my lord has waited. He has prayed 4 days.
4 days I'll try it. I'll try to file in 4 days.
Try and file it within 3
Lordship,
days.
and then I will file my reply. Lordship will record that.
Mr. Dr. N. Mozika submits that on instructions have been received. Praise without 3 days time to file affidavit. Praise allowed, yes.
And I will file my reply.
Yes, Mr. SN is permitted also to file reply to the same.
39.
Yes. Yes.
I'm praying for some more time.
Mr. Dr. N. Mozika prays funds allowed 3 weeks time to file affidavit. He'll file affidavit also.
We have not filed.
He'll file. Yes, Ms. S. Thapa prays funds allowed. Yes. Take down Mr. Dr. N. Mozika prays funds allowed for the 3 weeks time. 2 weeks time to file affidavit. Stop. Next para Ms. S. Thapa has entered appearance house number 3 with a similar prayer. This seems allowed. Also seems allowed. This after 2 weeks.
40.
3 weeks.
Your Honor, still may continue. Still may continue, Your Honor.
Yes. Interim
Still
prayer.
may continue,
Yes,
Your
yes, will continue.
40.
Don't have to shout. Yes. Interim order, if any, shall continue until the next day.
Now, these two connected matters. Earlier occasion, Learned AG said that he would be filing some affidavit bringing on how the payment was made to the other party. But
Yes,
he's not coming.
Lordship, I'm still yet to receive.
On the verge of being dismissed, this case, you saved it.
Right, right. Lordship, nearly we lost, nearly we lost, and Lordship, we rose up.
Lordship, if some more time, Lordship, I'm still trying to get some instructions.
It's pending for quite some time. Every 2 weeks may be given for filing if they want.
This court won't be here for some time. Yes, 3 weeks time granted to the respondents to file affidavits.
Explain this.
Pursuant to order dated 2/5/2023. Yes.
Much obliged.
41.
Lordship, 40, 41 connected.
Connected.
Second call. Item 11.
Much obliged.
In this matter, my lord, we are only agreed by the fact that, my lord, no opportunity of hearing was given. And the complaint is a very old complaint, my lord. What?
No, is one thing is inquiry continuing or stopped?
Well, nothing. After you file the reply, my lord, there is no further proceeding after that. And inquiry in section 6, second proviso, my lord, is a proper inquiry by an inquiry officer, my lord.
No, this when was the complaint? I took Act 59.
Complaint was filed way back on 23/10/2021 at Annexure 5.
Yes, Mr. Ganta.
Complaint was filed way back on 23/10/2021, Annexure 5, page 33.
Filed on
23/10/2021. Almost 2 years.
how many complaints are filed?
Only one complaint by the electors and by the clan which nominate.
Okay, this is.
Then
Yes, but this one says.
Show cause was filed twice. Once on by way of Annexure 6 on 1/3/2022. Thereafter, Annexure 6, page 39. Second show cause filed on 27/12/2022, Annexure 14, page 78.
Page?
78.
So it's not a case of suspension pending inquiry then?
Yes, it is.
How do you say that? If the complaint was since 21,
yes,
you didn't suspend him immediately.
we did not.
You issued a show cause.
Normally, we should have.
Yeah, but that's a correct. And with proviso says there are two possibilities. Correct. Where's that?
6 months.
No, I'll just take out the correct act. Yes. You didn't, in this inquiry, no inquiry officer was appointed?
Right now, after hearing all parties, we have passed an order on 11 April 2023, which they have not challenged.
When was he suspended?
It was suspended on 11 April 2023. A
19th
detailed
April,
order by the Estate Committee.
Page 88.
Page 88.
No, this is only a notification.
Yes, whatever.
We have passed a detailed order on 11
matter,
April.
but the substance is notification. Only one thing I think we require an affidavit, because this case comes in some kind of exception at same Mr. Kanta. Because there can be two possibilities. Straight away you suspend him pending inquiry, then he need not. But then once inquiry is started, then that comes. He cannot be removed without being heard. If you resort, you have to resort to one of them. You can't blow hot and cold with a sense that you institute. There's a complaint file. Show cause is called for. Inquiry commences, and you suspend him.
No inquiry is started. We have just taken cognizance of the complaint. We call all parties within
21 to 23.
Yes, there were so many issues in between. I'll not come to that. We finally decided to suspend pending inquiry. Charges have been framed, and an inquiry officer is a magistrate is being appointed. And the order that they have not challenged the suspension order 11 April passed by the entire executive committee.
Never supplied to us. Page 95, we are requesting them since 2nd of May.
Can you supply a copy?
Yes, we already supplied, but we can give it again.
But this case might fall in a cusp, like you say. Because whether this, you see, it's only to reality of proceedings, whether it's irregular or, it's bona fide or irregular.
We refuse to, we just prima facie find that there is a substance in the complaint, so we didn't want to terminate. We wanted a thorough inquiry to be conducted.
Well, just to come to that conclusion.
Now, one thing is that, proviso, second proviso, provided for no chief shall be removed from office, punished, suspension, opposition of hearing. Further, that a second proviso shall not apply
in case of conviction, and secondly, in case of order of suspension.
Suspension pending inquiry, yes. Suspension pending inquiry, that is a settled position, so there's no.
Suspension pending inquiry is okay. So right now we have opted to suspend pending full inquiry by a judicial ministry. We have not decided to terminate.
You do one thing, you furnish a copy.
Yes.
Because it's already over a month you suspended, so it's not that the other person's already taken over.
Lordship, if permitted, I can. It is here right now. I can give it.
That's between you councils, courts that take down Mr. V.G. Kanta, Special Counsel for KGTC, submits that a detailed affidavit be necessary in the instant matter. Detailed affidavit is necessary to bring to notice of the court the procedure adopted and the fact that it is a case of suspension pending inquiry term. How much time will it take to file the affidavit?
Well, Lordship, in fact, I wanted to just at this stage.
No, you file affidavit. In this case, it's different because it'll be a point of interpretation later on also.
They have,
We have to look at procedure also.
What I'm trying to say, Your Lordship, is this: that they have sought the setting aside of the
notification
of the Annexure 16 without praying for setting aside the order. So
They
what
didn't
I'm
have the
trying to
order
say
with
is
them.
that-
Did either you amend the petition or you?
Yes, that's what I'm
But I
trying
can
to say.
file an additional affidavit because I can challenge that
Yeah.
in the writ proceedings there is no set formula. My lord. I can challenge that by an additional affidavit.
The fact that it is a case of suspension pending.
It is noticed that the suspension will remain.
Before that,
Mr. Chief Special Counsel for the KHTC submits that the detailed affidavit be necessary in instant matter to bring to notice of to the court to the procedure adopted. The fact that it is a case of suspension pending.
You can avoid that, Your Lordship. Let them.
Okay, we strike that out. Okay, fine. So in the incident petition, as pointed out by Mr. Vigigan's Special Counsel, challenge has been made only to notification dated 19th April 2023, notifying the fact that the petitioner have been suspended on 11/4/2023. Stop. Next para, Dr. M. Zikala, Senior Counsel, submits that the said order dated 11/4/2023 could not be impugned as a copy of the same was not made available to the petitioner's term. He prays for as allowed to bring the same on record by additional affidavit on receipt of a copy from the respondents. When will you file it? You said after 3 weeks.
3 weeks.
To allow the petitioner to file the said affidavit.
I was praying something in interim also.
Interim now
It is only an acting, my lord. There is no vested court right now.
You want to stay acting and you want to be restored in office? In interim?
Only looking at the fact that he is only the person is only an acting, my lord.
If he is not taken over, maybe status quo would have been ordered. But the fact that that the acting is already in place, then it's a bit difficult. Yes.
Much better.
Hearing. Item 42.
Can we hear him?
My lord, don't bring this matter will be taken up tomorrow, my lord. I'll just prepare the matter.
Some urgency is there.
There's no urgency.
Then let it go after 3 weeks. And the premise other this is matter of the 3 weeks. But this court don't want to keep any matters CAV also for this week. That's the thing.
44. 44.
Should I appear for the second respondent, my lord? I'm praying for some time in this matter.
You made the senior counsel wait the whole day.
My lord, I apologized when he came also, my lord.
You see, there's some courtesy also. No, it's involved, right? Especially at least if you're going to seek time from the morning, you should have informed. How much cost do you want, Mr. Hruti? Yes, Mr. S. That is that due to personal difficulty, the matter be adjourned. So, yes, just after praise loud. Just after so.
45.
All right.
This matter relates to termination from service.
I'm praying for some time.
Who undertook to argue the matter?
Mr. Chandra was to argue the matter.
Which department? This is
the Women College. He was an assistant professor in computer application, and without issuing any show cause notice, he was removed.
When was he removed?
Well, 2009 he was removed.
2009?
2019 removed. 19 immediately we came.
Where is Mr. Chanda?
Chanda is not here to do notice.
Vinu is not here, we don't see him.
He's on leave.
Sometimes the Lordship will not be available.
Due to the absence of the senior arguing counsel. Stop. I think you argue it. I don't think your senior counsel doesn't come to court now. Yes, this is after 3 weeks.
46.
Yes, you're supposed to obtain instructions, Mr. Siddiqui.
Yes, madam.
Yes.
Here the petitioner has applied for the post of rifleman in the Assam Rifles, madam.
No, you're supposed to obtain some instructions. What instructions are supposed to obtain?
No,
last time Mr. Nyota said he may...
Yes, madam. I could not get, so whatever is there on record, I will make submission on the basis of the same.
Mr. Dr. Mozika is not ready today. He's on a pray on that DSGI. This matter after 3 weeks.
47.
We were required to file the additional affidavit in terms of the Lordship's order. We were filing in the course of the day.
What defects were there? 1 week time to correct the scene, that was on 8th.
Lordship, we were trying to obtain the notification, but we'll be filing in the course of the day, Lordship.
Yes, Mr. Enupur submits that due to unavoidable circumstances, the additional affidavit could not be filed in time. He prays for allowed further 2 weeks' time to file the same.
48.
Sorry, this court won't be here, that's why there's no point of giving 1 week time.
48.
Suppose obtain instructions, Mr. Thapa.
Some time, my lord, in this matter, Mr. Chanda was supposed to seek for instructions in the matter, my lord.
What instructions? Last time he said instructions.
Yes, my lord. Here, what had happened is some development has come up, my lord, insofar as their appointment is concerned. They were informed that the matter is under consideration. So that is why, my lord, we did not press for this petitions at the earlier stage, saying that we want to seek some instruction. Apparently, my lord, Mr. Chanda was supposed to take that instruction, my lord. He is in direct touch with the client. He is not there today, my lord.
But as far as we are concerned, no such.
But that had come from them, my lord, the petitioners. So they, on their sayings, my lord, we sought some time.
You take instructions. Mr. Chanda, the arguing counsels who supposed to instruct that present court today, Thapa on his behalf prays that the matter be adjourned to another date. Praise the loud list also and so.
49.
Same problem.
This is a contempt? No.
No.
50.
She was for last order, Lordship. She's supposed to bring some report on the investigation. There is an order, Lordship. Order dated 025/2023.
Yes, you got the proper records.
My lord, I got some records.
But they could not retrieve the whole thing. The original record I have got. They made a statement on that petitioner has given a statement, but my lord, that is not there.
Then what does that mean, Mr. If a statement should be there part of the records? It's already been filed, correct?
This is already there.
They have sent the
Then?
original copy.
This is already there in the earlier, but this is not what my lord has passed an order for bringing it.
No, because he said he should have never heard, correct?
Yes.
Before the mission, before
That is
the mission coordinator.
Yes. It's not there because they just make a statement. I was never given an opportunity. I never participated.
Rock mission coordinator. That there was an inquiry done, then she was heard, but she said that's the only thing. What to do?
Lordship, we go for the entire case. This is the
some more time. But this is the original.
Their opportunity.
Yes, exactly. Mr. Kibi today has produced the original inquiry report. However, without the supporting documents, wherein statements have statements have said to be recorded. So we allowed further 2 weeks' time to obtain the same. As we'll hear the matter and he'll come out victorious. This is the tentative view of the court.
That is fine.
The original records return in the meantime too.
I may be allowed to inspect if Lordship.
Nothing there to inspect.
Just to inspect.
Already a part of the evidence.
He wants to see his original. He just wants to see his original.
If something is there.
Yes, if something is there. Yes. Just after soon.
Lordship.
51.
Possible, Lordship.
Connected with another matter, WBC number 393 2018. There is a dispute between the Nakmas. So this matter may be kept in abeyance for at least 4 weeks. In the meantime, that will be heard, then it will be decided.
By whom? Who is before which court? This court only?
No, another one is before Justice Bindu.
Mr. A. Siddiqui counsel submits that connected matter is pending before a coordinate bench. He pleads that the same became in abeyance to avoid the outcome of the other case. Stop accordingly. Next para, this is a matter after 4 weeks. Yes.
54.
This is that matter, my lord, where, my lord, for a snatching of a mobile phone by a police authority, my lord, the respondent number 3 filed an application before the Human Rights Commission. Now, my lord, what had happened in this case, my lord, the petitioner before your lordship is a police officer, my lord. On 30th of December, my lord, 2020, at around 9:45 a.m., he received a call, a telephonic call from the SP, whereby he was sorry.
Any urgency in the matter?
Also urgency, my lord, the proceedings.
We'll hear it. Let Mr. Khera come in person. Yes. This is matter after 3 weeks. Yes.
55.
The petitioner is whom? Who's the complainant? NGO. Urgent matters. Any urgent matters?
It is little urgent, Lordship, because I'm
Okay.
not getting the
Start. Yes.
I seek little accommodation, your Lordship. What happened? I'm not fully prepared today, your Lordship.
You're not feeling prepared. You're not fully prepared.
My lord, he is required to bring some
He's got to?
instruction. This instruction 17/3/2023. There is a direction, Lordship.
17?
17/3/2023.
17.3.
Yes.
What instructions, Mr. Ibrahim?
Yes, Lordship. The little difficulty is that I have received instruction, but while I was opening, I think I put in another file. I just opened the file. That report is not in the file, so for that reason, I just seek a little accommodation. Yes, Your Lordship. I have received, but while preparing, I think I have misplaced that.
The after tomorrow?
In another file, I think I'll just check and I just seek a little.
Is it really urgent?
Because
how many days you cannot pay? Fixation of fee or pay?
Revision of pay, Lordship.
You're receiving pay now, correct?
No, I am not even that also stopped, Lordship, because I have filed the case.
How many months pay has been stopped?
No, I don't.
They said that he is entitled for fee pay commission, but in understanding that he is not entitled for fee pay.
Okay, but why you stopped his pay then under any commission also? You're working as what?
We are the home guards.
You're home guard.
Home guards. Earlier, that revision of pay, we are getting the same benefits, my lord. All of a sudden, in 2017 revision of pay, they have not accommodated us. They have not denied also. It is now in the counter affidavit, they are saying that it is the home guards. They have to issue the orders. That is why the court has asked the state respondent to seek instruction on that aspect, Lordship. It is not that they are denying, Lordship.
No, but I don't understand why they're not paying. Why are you not paying?
They are paying the LA, they were receiving.
No, are they paying anything at all now?
They have been rewarded to for pay commission. Only they are getting the for pay commission.
So whatever it is, if they have be paid something, they can get arrears. If the court decides that the entire pay commission, then you have to pay the arrears in salary. That's all. But the thing is that he's saying, he's submitting that they're not getting any pay at all now.
My lord, last I think January this year I got the salary. After that they have stopped. I don't know.
And how will he survive?
That is.
He can make provisional pay, whatever it is.
That I'll instruct them to pay that for pay commission. Definitely. Yes.
Your submissions are correct. We can note them down.
Yes, Lordship.
Yes.
I have
The subject matter issue in the present case is with regard to the
benefits of
non-grant of the benefits of the fifth Meghalaya. Your marketing board or your from notary?
The subject matter issue in the present case is with regard to the non-grant of the benefits of the fifth Meghalaya.
The fix, no, the one, no, not Meghalaya, is a non-grant of the revised scale of pay as per the revision of pay rules 2017. Stop. To the petitioners, to the petitioners who are stated to be Home Guard personnel. Correct? Okay. Next paragraph, Mr. Sheikh, S.A. Sheikh submits that while the matter is pending before this court, when did you file it? Last year?
Yeah, 2022.
If the pay of the petitioners has also been stopped since January 2023. So, for reasons unknown. So. Next para, Mr. H. Abraham. Some of the two instructions have been received. You're not aware they will not be paid.
No,
he is not aware as to whether the petitioner's pay has been stopped. He is directed to take further instructions. It is further noted that pendency of this writ petition shall not stand the way of the shall not stand the way of the petitioners being given salaries, provisional or otherwise. Yeah.
57.
How can deny salary?
Please, Lordship, I pray your indulgence to have this matter after some time, Lordship, maybe after 2 weeks.
Yes, on the principle, this is a matter after 3 weeks. Yes.
Most blessed, Lordship.
58.
Or should the private respondent has filed an application for recalling of
Who?
the order?
Your respondent number?
Number 4, Lordship.
For what?
Recalling of the order dated 21/3/2023, Lordship.
Ex parte order was passed
Proceedings.
against him.
Why didn't appear earlier on?
Lordship, what happened is that
You are
on
whom?
receiving-
You are Hasina Zaman.
Yes, Your Lordship.
Yes.
On receiving notice, Your Lordship, I had appointed a counsel. However, Your Lordship, even when I tried to contact the counsel also to know about the status of the case, I could never got in contact with him. Thereafter, Your Lordship, it was just in the month of April.
What did the earlier counsel enter appearance before the court?
No, Your Lordship.
At all?
No one entered appearance, Lordship.
Okay, take down respondent number. Your respondent number?
Number 4, Lordship.
Miss case number 62 or 2023 and WPC number 294/2022. This is an application filed by the respondent number 4 stroke applicant for recall of order dated 21/3/2023, whereby this court has ordered that the matter be proceeded ex parte against the said respondents. Next paragraph. MS CB Savian Leonard, counsel for the respondent 4 stroke applicant, submits that the non-appearance of the respondent number 4 was due to reasons beyond our control and entire fault of the earlier counsel who had been entrusted with the case. Stop. She further submits that she has been duly engaged in a such filed application for a call to allow the respondent to file affidavit. Yes. Next by Mr. Emanumpu has no objections to the array made by the respondent number 4. Stop. Next part in consideration thereof, the order dated so is recalled, and the respondent number 4 is allowed to file affidavits in the main case. This case stands disposed of, allowed and disposed of. Next, in the main case, in view of the order passed in WPC number so and so, in the main case, 3 weeks time is granted to the respondent for to file affidavit. This thereafter.
61.
Yes, Mr. Kajing.
In this case, my lord, the petitioner has requested has filed an application to the appropriate authority, respondent number 1. But since 2000...
That regarding the drilling?
Yes, my lord. Since 2017.
You file affidavit, Mr. You filed?
Yes, Your Lordship, I filed.
What do you see in the affidavit? Why are you not allowing drilling?
Because it is situated within the radius of 1 kilometer.
Not only that, also because they say that is in 2007
Excuse me,
of the Sinang. So my lord, actually any objection of the Sinang has no
relevance.
No relevance.
It's not a technical objection.
Technical objection is more important. And respondent 2 is a deputy commissioner, is chairperson of that. He did not file any affidavit. And 3 and 4.
No, you see, there's a committee, correct?
Yeah.
There's a committee that goes through this, and then that committee recommends and permissions are given.
Yes.
But just recently, in my own locality, also one big drilling thing came and said, no, we have permission, so what can you do?
Yes.
It created a big racket for 2 nights.
But the problem is that, my lord, there is no water there, and the whole Nongra PSC did not supply any water. Of course, it's a different issue that he's been lime cry and others.
Let's see your affidavit. Where do you say that permission could not be granted, Mr. Abraham?
That is a paragraph, I have mentioned it in paragraph
913.
Is this borewell working? PhD one?
That
one is not working.
That I have
working.
That I have stated in para 14, Your Lordship.
It's not working.
Para 14, Your Lordship. The relevant statement is para 12, 13 and 14, Your Lordship.
They just want to deprive me, my lord. It's not working. Right from the beginning.
Para 14 now.
I have already replied in my rejoinder also.
What to do in a case like this? Where's the committee report? This one?
As a matter of fact, everywhere I still keep till date, my lord.
And if I'm pleased to read para 14 of my affidavit, Your
No,
Lordship.
come to annexure page 9. Approved, not approved, near the catching area spring, approved. Where's that disapproval? This your name doesn't appear here.
She did not even they did not even put it before the committee, my lord. That's why my prayer is that be placed before the committee.
Yes. Where's the application? I see that this one also. Mr. Manta's daughter also got permission.
Everywhere they can.
Number 13.
And right now that whole Nora is supplied by Kong Doris Pongrop. She also same thing only, and she's supplying water. And of course I should not point out.
See, Mr. Kinjing, this is your case, not a one-off case. No one's been given permission by restaurant because there's a monopoly going on. That's all. So you are suffering because you want to break the monopoly.
Of course, from that uncle is your lordship.
That is why.
Very correct. And just imagine you have to spend a lot of money only for water.
The waters in Shillong become so scarce. Even I'm having water problems.
At least in that area in Lumpari, and then like that my area, of course, water is
That's plentiful.
plenty.
Our side, because all the catchment areas now, before we used to get our water from that Loom Ding Met and from this Loom, that Dingling, whatever, it's near to Prakasal side, a lot of springs up there. What is now, many settlers are there, they have diverted all the water.
And as a matter of fact, I think the Honorable High Court should bring the attention of the court also. The catchment area now,
they're building houses.
They are building houses.
And even the water
Yes.
also is all, it's...
Previously, we cannot see anything because of the trees. Now, everything become very clear. That Dudrashan and others also become very clear now.
Now, in your area, Mr. Kejing, before,
Yes.
that monastery was the highest point.
Yes.
When you look from down. Now, you have houses on top, monastery is down there.
Yes. Plenty of houses. And of course, the system here is very bad because registration can be done on the recommendation of headman also. That's a big problem.
You didn't make Shillong party?
No, because they are not required.
No, because now he said that 7 in Para, he's made that since a agreement with Shillong.
That is by the respondent number 1 only.
Was you put application for the committee? You put it for the committee.
That is my prayer, madam. Let me please before the committee. Let them keep a specific order. My prayer, my lord, is to process the application dated 19/7/2017, my lord. Let them process this application.
Where is which annexure is your application?
Page 19, my lord.
Page?
19, 19.
Class case in
19.
It's made before the committee.
Yeah, yes, my lord.
We'll do one thing. You file a fresh application.
No, of course, it is a bit.
Because they have not examined your case at all.
No, they have replied also.
The committee not replied. It doesn't come the list also approved, not approved.
No, they said that file again. So we have already filed again also. That.
Where is that?
In page 57, my lord. With reference to the subject cited above, I am informed that 25th meeting so and so, in respect of the district level committee on groundwater held on 7 October, your application requesting permission for drinking water at your.
Oh, here there's a committee. Then it's
has
already
not been
given
approved.
that finding because the present one at this 100 meters. Okay, take down. The petitioner being aggrieved with the non-grant of permission why? Non-grant permission on it's a on the non-grant permission on her application dated 19/7/2017 for drilling of borewell is before this court by the instant writ application stamp. The facts, the materials as placed indicate that this 13 the permission of the petitioner was rejected by letter dated 13/10/2022 bracket lecture 8 Roman 8 writ petition on the ground that there was a presence of one capital PHED borewell descent of 100 meters approximately from the proposed site of borewell of the writ petitioner. Further submit that it is not considered a 2017 application, that's what you say.
Yes, madam.
Yes,
And moreover, under 26(7), madam, in page 55.
It is further submitted that
in page 55 and
the application of the writ petitioner dated 19/9/2017 has not been considered in its proper perspective. Now, what else you want to show?
Then in page 55, madam.
Yes.
They have asked me to file a key application.
Submit. This
Yes,
is
I have submitted. A joint inspection for drilling will be conducted 26/7/22.
Where does it say? Where does it file special application? Does not see anywhere.
We have to reply to this, my lord, of course.
You not reply to this?
Yes.
No site inspection, did you go or not?
Okay.
26/7 is just site inspection be there, and 13/10 is a rejection.
Is there, your answer?
Where?
In page 51, my lord. Dated 29/5.
Oh, that we've seen. The 29/5/2022. This is a new application.
Yes.
No, but rejection isn't rejection 13/10. That's what the court is saying. Rejections in 13/10. These all before that.
Of course, you have instructed us to file again. That's why we filed this also.
No, 29/5 you file. Now site inspection is, see, with the 29/5. Then on 26/7 is a site inspection, right? And then 13/10 rejected. So what remains?
Because that meeting was held on 7 October. So as soon as I know that they have rejected, I have filed this petition. This petition.
No, petition what do you want? I've rejected it. So only on the ground of police.
This was submitted that application of the petitioner dated 19/9/2017 has not been.
No, POM na kato. So submitted to POM 17 to POM na kato. Sure kato?
The materials as please indicated that the permission of the petition was rejected by letter dated 13/10/2022 annexure 8 to the petition on the ground that there was a
PHED.
PhD
Borewell.
meters
That is 100 meters.
approximately from the proposed site of
The borewell. Petition's borewell is. Stop. The next council basically submits that.
So, my lord, the rejection is highly
No, this
the jurisdiction.
submits that the ground for rejection is misplaced as much as the PHET borewell is a non-functioning borewell. So, he therefore prays that the application of the writ petitioner be revisited in view of these circumstances. Copies, photos of the PHED borewell stated to be non-functional has all been annexed at Annex 9. Next paragraph. Ms. H. Abraham, on behalf of the respondents, submits that the PHED borewell is very much in existence and is part of an ongoing scheme, namely Nongra Water Supply Scheme Phase 1, and that the same will be commissioned shortly after power connections given by the MECL. He further submits that it is not a fact that the PHD borewell is non-functioning. Next paragraph, having heard the counsel of other parties, and the only point in contention being the rejection of the...
May I say something? Because my lord, the main objection they didn't give it to me is because of that objection from the Sinamana. So actually, that is a highly irrelevant matter.
Then you should make them party. If not make them party, then how can a man? They should come and say why they're not giving. Make the Shnong a party.
But we came to know only when they filed this.
No, we'll allow you make party then.
Then
you take instructions then, Mr. Kinjing.
Make them party.
After hearing some time, Mr. Case Kinjing, please be allowed to obtain instruction as to whether the Nongra Darbar should be added as a party in the present proceedings. This praise allowed list up to 3 weeks. Yes.
Thank you.